Yeah, I started the live.
Should I start?
1 minute.
Okay.
Now, when you begin the slideshow from the first slide, let's go on the first slide.
Yeah, you can start, Shaijal, now.
Okay. Good morning, everyone. I welcome to you all to the WebImpact webinar series organized by JLSR General in association with Just Commune and Law Column. This WebImpact webinar series has been organized to provide great learning experience to all the law students throughout India. I'm Shijal Shekhar. I will be moderating today's session on the topic Acing Moot Court Competition. Now, I would like to introduce you all to our chief guest speaker, Mr. Rachnendra, sir. Rachnendra, sir, is the co-founder and COO of Memo Pundits, which is India's first mooting school. Rachnendra, sir, has done his graduation from National Law University, Odisha in the year 2016 and practiced litigation for 2 years. His passion for mooting was right evident from his first moot court, where his team bagged the best memorial and runner-up citation at G.H. Raisoni Moot Court competition. His exceptional memorial making skills have guided numerous moot teams to win the best memorial citation at national and international level, such as Philip C. Jessup International Moot and many more. So, on behalf of my team, I welcome to you, sir. It's a great honor to have you as our chief guest speaker. Now, I request to you, sir, to please begin with the session. Over to you, sir.
Thank you, Shijal, for such a gracious welcome. Okay, thank you so much for having me, and it's great that you guys are organizing such webinars. I think we're good to go, right? Everyone's on YouTube Live.
Yes, sir.
Okay, perfect. All right. Lavanya, can we begin the slideshow? Yeah. Okay. Hi, guys. Hi, everyone, whoever is listening me. So today's session, today's webinar, I've structured in a fashion in which even if a slight fraction of the students are new to the concept of mooting, we will venture into the entire aspect of moot court competitions from the beginning. We'll touch upon the basics, and then we'll also be talking about drafting, formatting, specialized skills like drafting, formatting, and also oral arguments and the nuances of oral arguments. So, okay. Can we get the second slide? Yes. Yes. So first of all, as I told you, if anyone of you has no clue about what a moot court competition is, like me, when I came to law school, I had no clue what a moot court competition is. But gradually, मेरे को तो first year तक नहीं समझ में आया था moot court क्या होता है. But gradually, you come to face with it and you learn. So basically, a moot court competition in law school is you could categorize it under a co-curricular activity, but to be frank, it is gaining way more importance than a co-curricular activity. It helps you in a manner which helps you grow as a lawyer, and this is one co-curricular activity which you will only get in a law school. Moot courts, you write research papers everywhere in every college, be it any background, engineering or anything, but moot court competitions, you only get to have moot court competitions in law schools. So basically, a moot court competition is a mock court in which we simulate a court hearing. But having said that, it is very important to note that there are slight differences between how a case proceeds in a real courtroom scenario and how a moot court competition proceeds. For example, one very basic difference which many students don't know, I did not know this until I was in third year, I guess. The issues which are framed in a moot court competition, they are framed usually in the proposition itself. They will give you the issues, or they will ask you to come up with your own issues. We'll deal into what issues are in detail. Don't worry about that. But in real courtrooms, the issues are framed by the bench. The judges frame the issues, they see the facts, and then they frame the issues. So this is what a moot court competition is in brief. Now, the importance of mooting in law school cannot be overstated. This you only realize जब तक आप law school में होते हो. You think mooting is fun. Mooting is just something which will let me stand apart from the crowd, which is true as well. But when you after your 5th years, when you will enter into the job market, you will realize that as far as your marks are concerned, they definitely play a role to help you seep in the job market, to break that barrier. But once you are in the job market, you need to escalate, you need to climb the ladder. And the only thing which will help you climb that ladder is your skills. And moot courts specially garnered 3 essential skills which are very very important. The first is formatting. ऐसा लगता है कि formatting important नहीं है, but it is important. We are going to talk about that. Researching is the bread and butter for any lawyer. And drafting. These 3 skills, you'll be able to polish up these 3 skills, work on them if you are engaged in moot court competitions on a continuous basis. Apart from these 3 skills, you get to, yes, most importantly, you get to arrest your fear of public speaking, which is very important. Because until our school, when we are in class 12th, our traditional school never focuses on a student's public speaking skills. All the public speaking which we get, which I used to get, was the Thursday assemblies, and once in a while you get to recite the prayer. That was all the public speaking I got to do. But apart from that, moot courts will help you get over that stage fright and address a lot of people without any fear. So, which is extremely important when you will be practicing in district courts or Supreme Court or High Court. So yes, another benefit of moot courts is networking. This is a practical benefit. I personally know someone who secured his first tier 1 internship through a moot court judge. He went on to intern there again, and he secured a job in that firm as well. So this happens. Obviously, सबके साथ नहीं होगा, but if you are going to outcase yourself in the moot court, this may happen with you as well. So networking हो गया. Many reasons, many benefits of a moot court competition. Now, the next slide, Lavanya. And now, guys, we are going to proceed in a manner in which a moot court typically proceeds. So this is the first thing which happens in a moot court competition. You have to choose a moot court competition. Now, choosing a moot court competition and the team formation, we are going to discuss that. In order to choose the moot court competition, your priorities need to be very clear. You should know why you are mooting in the first place. Now, there could be 2 reasons for mooting. One could be that you want to bag a prize. Okay, you want to win something, you want a citation, and you want to show it off in your college. That's it. That could be one reason. The other reason could be to gain experience. Now, you must have noticed there are certain students who go for a tier 3 moot. They bag a prize and they have confidence, and then they later in their second years, third years, they go for good moots. There are some students who directly go for international moots right in their first year. Now, that approach is also not bad at all. If you're clear that you need to gain experience before, तो वो first year मेरे पास है, and I could gain all the experience, I could commit all the mistakes I want to right in my first year, then go for an international moot, go for a tier 1 moot. But then you have to be very clear about the team which you are forming. Before choosing a moot, you need to form your team. So the next point which in this slide is the team related to team formation. Now, with respect to team formation, guys, friendship is not a criteria to form a moot court team. If friendship is the criteria to form a moot court team, then rest assured that friendship is not going to last after the moot court ends. Okay. So you need to, but having said that, I'm not saying that the moot teams the members need to be sworn nemesis or something like that. There needs to be a mutual understanding between the team members. There needs to be a mutual understanding of space between the team members. Moot courts कभी-कभी hectic हो जाते हैं. You need to have synergy amongst the team members. अगर एक बंदा एक काम कर रहा है, दूसरा काम कर रहा है, तो जब दोनों साथ में होंगे तो their productivity, their output should definitely increase. This is what I mean by synergy. But guys, be very, very judicious when you are forming your team. And this is the first stage. You have to choose a moot, you have to make your team, and you have to choose a moot. obviously intra moot courts होते हैं, उसमें we all know the reality, friendship is the only criteria to form a team most of the times, but intra में it's okay, but do not go for national or international moots forming a team on the basis of your friendship. So yes, let's move to the next slide, which deals with moot court propositions fact sheet. Yes, अब जब आप moot court choose कर लेते हो, आपकी टीम बन गई है, moot court choose कर लिया है, after some time moot court problem will be released. अब moot court problem को हम कई अलग अलग, we know it by different names. One of them is moot proposition, fact sheet, moot court compromise. जैसब का जो problem होता है उसको moot court compromise बोलते हैं, और moot court record. Now these terms can be used synonymously, but whichever moot you are going, that moot must be using one term, either proposition or compromise or record. It's preferable that you stick to that term and use that term. Now, when a moot court problem is released, even before that, your preparation should begin. How is that done? Before the release, you need to do two things. That is, one is you need to be aware about the subject area which is being dealt in that moot. For example, if you're going for JSF, you know that it deals with international law. Now, my juniors in my school, my friends in college, they went for JSF. They were the semi-finalists and they did great in that moot. Those guys prepared 1 year even prior to the moot court problem was released. They were sure that they're going to participate in JSF. उन्होंने JSF का book आता है, international law का book आता है, Malcolm Shaw. They read Malcolm Shaw thrice or 4 times, I guess. They completely read it in and out. उनको international law के बारे में इतना subject area पे इतना command हो गया था that when you read the problem, you just understand what is going on in the facts. Okay, so you could use that time before the release of the moot problem. You can garner a command on the subject area. You can read a basic statutes and of course landmark judgments. अगर आपको पता है constitutional law moot है, fundamental right पे हो सकता है, तो just 14, 19 या 21 पे बहुत ज़्यादा chance है. So you could just brush up with the basic law, and this is what you can do before the release. Once the moot problem is released, now then your game begins seriously. So जब problem release हो जाएगी, the first step which you need to do is, next slide. Yes. After the release, the first thing which you need to do is you need to read the moot problem as many number of times as you can. You wake up in the morning, you read the problem. Before sleeping, you read the problem once again. You read it as many number of times as you can. This is the only hack, actually. This is the only hack which is the most assured way of gaining command on your facts. Okay, every time you read the problem, you will get a different interpretation of the facts. Now you do not need to read the problem in a very dry fashion. You need to do certain things while you're reading it. For example, एक दो बार moot problem पढ़ने के बाद you'll realize there are certain keywords in the proposition which you have no clue about. So you just keep on underlining in one read कि वो कौन से ऐसे words हैं जिनका आपको मतलब नहीं पता है, और जितना आपको मतलब पता है, that is not enough and they require more interpretation, more research. Just underline those words. For example, if the moot court proposition starts with a line that XYZ company, XYZ Private Limited is a company incorporated in Indiana Islands. So isme most of the students, they'll underline incorporated, they'll underline company, but what they forget is वो company का जो नाम है ना, XYZ Private Limited. You need to underline, you need to know why, what is the meaning of private limited. किसी company के आगे private limited क्यों लगाते हैं, ठीक है? And then when you read the problem in its entirety, तो आपको पता चलेगा कि उस company के ऊपर कोई liability fix करने वाले हैं, but क्योंकि वो private limited company थी, तो उसकी liability वो अपने आप contain कर रही है. We are getting into the law part, but yes, this is how you find keywords and make sense of the facts. So keep underlining those keywords and keep researching on them and keep reading them again and again and again. So yes, the second point is hunting keywords and interpreting the proposition. Third is understanding disputed and undisputed facts. Moot problem में कुछ ऐसे facts होंगे which are just given out there, all right? Those facts are not contested, and there are certain facts which both the parties must be claiming, that XYZ claims to, that this happened. That very fact is disputed because it is claimed by one of the parties. Usually courtroom practice अलग होती है, court तो अपने जो undisputed facts होते हैं वो court के अलग से release होते हैं. But moot courts में in the problem there may be disputed and undisputed facts. What you need to do if you're if your argument is solely based on disputed facts, then that argument is not as strong as an argument which is based on undisputed facts. I hope you get the picture what I'm trying to say. So this must be your task. You must be very mindful while reading the proposition कि facts कौन से disputed है और कौन से नहीं है. Because many times students rely on those facts जो कि disputed है. They just use them in their oral pleadings and the judge points it out and then it's very embarrassing. और फिर marks तो कट ही जाते हैं. The last one is separating material and immaterial facts. Material facts and immaterial facts क्या होते हैं? Okay. Issues होते हैं हमारी प्रॉब्लम में, जो मेन डिस्प्यूट्स होते हैं, इशू एड्रेस किए जाते हैं. उस किसी भी इशू से अगर कोई फैक्ट रेलिवेंट है, इवन स्लाइटली, then that fact is material fact. So if a fact has a bearing on an issue which is to be decided, then that fact is material fact. अगर वो ऐसा fact है जिसका कोई भी issue से कोई लेना देना ही नहीं है, वो बस लिखा हुआ है. For example, कुछ भी, India is a populated city. बहुत सारे ऐसे बकवास facts होते हैं प्रॉब्लम में जिनको आपको इग्नोर करना होता है. तो yes, you need to be clear कि material और immaterial facts क्या हैं. कभी-कभी जजेस ऐसे क्वेश्चन भी पूछ लेते हैं, what counsel please state 5 material facts from which benefit your client. So okay, I guess this is it on the proposition. The next slide is dealing with the issue part. Hold on, guys. Yes. Now this is a very tricky and a very important part, क्योंकि कभी-कभी मूट कोर्ट प्रॉब्लम्स में या तो इश्यूज दिए होते हैं, दे विल, किसी भी प्रॉब्लम का पहले स्ट्रक्चर बताता हूँ. मूट कोर्ट प्रॉब्लम इज डिजाइन्ड इन अ फैशन जिसमें सबसे पहले दे इंट्रोड्यूस द पार्टीज टू यू, ठीक है, एंड देन दे गिव अ बैकग्राउंड ऑफ द पार्टीज, एंड और फिर उस बैकग्राउंड में दे टेल यू हाउ बोथ द पार्टीज वर इंटरैक्टिंग, बिकॉज देयर नीड्स टू बी सम इंटरैक्शन फॉर अ डिस्प्यूट टू अराइज. So they'll tell you how they were interacting. Then in amidst that interaction must have something happened which led to the dispute. Or फिर dispute वो लिख देते हैं, and after that dispute there are two options in the proposition. या तो they will be giving material, they will be giving the framed issues, or they will ask you to come up with your own issues. Now that's a different ball game altogether कि अपने खुद के issues कैसे बनाने हैं. What is the line you draw to, you know, not make a dispute an issue. But yes, let's talk about the basics first. So issues are basically the disputed facts, जो भी point of disputes हैं दोनों parties में, which are to be decided by the court. That is an issue. And if the issue is not given in the proposition, what you need to do is you need to read the facts. Okay. How? Yes. The second point is issue formation. So you need, if the issues are not given, you need to read the facts. You need to know कि दोनों parties में what was the point of dispute, दोनों में जो अनबन बन गई last में, why are they actually coming to the court? There must be some relief which one of them is seeking from the court. So the point on which the party is seeking relief is the actual issue. Now the issue formation पे one more thing, just try to, you know, make the, whenever you're framing issues, make the issues very simply in a very crisp language. Do not use very articulate language just to sound very flowery, but use very crisp, simple and impactful language. और कोई standard तरीका है issues बनाने का, बिल्कुल simple है, इससे मत deviate कोई भी करना. Frame an issue in the question format only, whether or not, and last में उस question उस issue में question mark, just place a question mark. This is the right way of framing an issue, and just stick to it. Do not use very innovative methods, क्योंकि इसमें बहुत ज़्यादा है नहीं scope innovation का. Okay, so this is how you frame an issue. Or one more thing which you need to keep in mind, if you're making an issue from the appellant side, from the side of someone who's aggrieved, for example you've made 4 issues, तो जो दूसरी साइड से आप मेमो बनाओगे ना, make sure that you reply to all those 4 issues. दूसरी साइड से भी same number of issues बनाना is advisable, it's recommended, and it's necessary as well. क्योंकि अगर आपको पता है कि एक तरफ से वो क्वेश्चन उठ सकता है and you've not replied that question from the second side, what if your opponent raises that question and you don't have a reply? So just make sure that if you're framing 4 issues for the appellant, you need to frame 4 issues for the respondent as well. Now the issue division among speakers, this is a very confusing point. बहुत सारे बच्चे, और इसका कोई भी watertight rule nahi hai. It's a confusion. For example, there are 4 issues and speaker 1 wants to deal with issue 1 and issue 3. Speaker 2 wants to deal with issue 2 and issue 4. Can it happen? It can happen, but I'd never prefer to venture into any such agreement, any such arrangement जिसमें speaker 1 के पास पहला और तीसरा issue है. बहुत सही होता है अगर speaker 1 आता है. Although you lay a roadmap oral arguments में, वो मैं बताऊंगा कैसे कि स्पीकर 1 क्या बोलेगा, स्पीकर 2 क्या बोलेगा. बट इट्स बेटर अगर 4 इश्यूज हैं, स्पीकर 1 शुड डील विद इशू 1 एंड इशू 2. आफ्टर दैट स्पीकर 2 शुड डील विद इशू 2 एंड इशू 3 एंड इशू 4. So the division, and then you need to be sorted about the division of issues ki. And yes, one more question arises on this ki, for example, I'm speaker 1, do I need to know speaker 2 ke issues in entirety? You don't need to know, you don't need to argue those issues in front of the bench, but you need to have ample clarity कि अगर कोई question bench raise कर देता है, तो you are not looking here and there, or you're just asking the bench to seek assistance of your co-counsel. It's better to be prepared with those basic questions and basic answers. So have a better understanding, have a rudimentary understanding of all the issues. Both the speakers should have it. Now the next slide. Once अच्छा ठीक है, अभी हमने मूट प्रोपोजिशन डील कर लिया है, हमने इश्यूज समझ लिए कैसे बनते हैं. अब जब इशू हमारे पास बने हुए आ जाते हैं, when we have the issues, when we have the point of disputes, now begins the research. So the next part of this webinar will be dealing with what actually research is, and we'll be focusing on research with respect to the moot court competitions. Lavanya, can we have the next slide? So the purpose of research, I'll be telling you. Yes. So this is how the research progresses. I think I mentioned it. Yes. The first point is that I think we can have all 6. It's fine. Yeah. So the first is the old school style as we've written it. So we all have done this. If you're in first year, you may have a clue about this. Commentaries, law books, libraries में जो भी books रखी रहती हैं, उन पे जाना, उनको, that is the most basic thing you need to do. अगर constitution का moot है, तो you need to go and pick up DD Basu. आपको अपने जो keywords हैं moot proposition के, वो DD Basu में ढूंढने हैं. तो जब आपको वो keywords मिलते हैं DD Basu में, in any commentary, I'm just taking an example, then those keywords will also have a separate interpretation in that commentary, and that interpretation will have the authority or the case in which that interpretation was given. So, sorry, that's the preliminary research which you need to do. And it is also bulletproof, by the way. And the second task is you need to find applicable legislation and landmark judgments. Again, we've talked about that. अगर आप, for example, right to privacy पे अगर आपका moot है, तो you need to find the constitutional law. Right to privacy किसमें होगा? Right, Article 21 right to life में है. Right to life आप देखोगे जाके, तो ये एक जजमेंट है बस, पुट्टास्वामी जजमेंट, जिसमें आपको राइट टू प्राइवेसी के बारे में सब कुछ मिल जाएगा, बहुत डिटेल में डिस्कस किया हुआ है. So if that is an issue in your moot, you need to know Puttaswamy judgment in entirety. You need to know Article 21 in entirety. बहुत ज़्यादा question ये होता है कि, for example, my issue deals with Article 21, so right to privacy. Do I need to know about right to sleep? Do I need to know about all the fundamental rights because my moot is concerned with the fundamental right? I guess not. But you need to have a fair picture, because if a question is raised, you can't be clueless. So अगर fundamental rights के ऊपर moot है, you need to know all the fundamental rights. इतना basic आपको आना चाहिए. You don't need to know the authorities of fundamental right to religion, choice of religion. ये नहीं पता करना है. But you need to know कि हाँ भाई fundamental right of religion जो कहाँ पे कौन से provision में दिया गया है. So this is how a basic understanding which you need to gain about the law which is concerned with you. And again, we keep going back to the commentaries. जैसे जैसे हम law पढ़ते हैं, हम statute पढ़ते हैं, we read the landmark judgments, we just keep visiting the commentaries and the books because they are the guiding beacon of our research. वहीं से सारी research emanate करती है. And in the 6th point, I am going to tell you how. The third thing is we go to the research databases. अब research databases में we have lots of research databases. Keen Online है, JSTOR है for articles, Manupatra है, SEC Online है for case laws, and please इंडिया कानून साइट मत करना अपने मूट कोर्ट्स में, इतना खुद पे रहम करना तुम लोग. सिर्फ मनुपात्रा एंड SEC Online, stick to these resources. अपार्ट फ्रॉम दैट इट मे सो हैपन कि आपके पास कोई ऐसा इशू आता है जिसमें कि बहुत ज्यादा लॉ एप्लीकेबल नहीं है. इट maybe the organizers of the moot court want you to argue on jurisprudence of a particular issue. So you need not, it may not be always possible that you have a certain law on that. हो सकता है उस पर कोई precedents ना हो, and fourth and fifth point are dealing with that only. In those cases, it's very rare that you will end up having a binding argument. So in such cases, what you need to do is you need to come up with persuasive arguments. Persuasive arguments, maybe you need to know how much persuasive it is, because it may be strongly persuasive, it may be weak. The persuasion could be weak of that authority and of argument. अब strongly persuasive क्या बोलेंगे, जैसे कोई article अगर लिखा हुआ है and if that article is in a reputed journal, तो उसकी authority, persuasive value बढ़ जाती है. And if it is written by some scholar in that very subject area, तो उसकी वैल्यू और भी ज्यादा बढ़ जाती है. एंड यू कैन आर्ग्यू मोर ऑन दैट बिकॉज इट्स वेट इंक्रीजेस. तो अगर आपके पास कोई भी लॉ नहीं है, ट्राई टू हंट फॉर दोज अथॉरिटीज जिनका वेट ज्यादा है, जिनकी पर्सुएसिव वैल्यू ज्यादा है. एंड इफ एट ऑल यू नीड टू फाइंड अ केस, अगर आपके पास फॉर एग्जाम्पल इंडिया के सुप्रीम कोर्ट में आप आर्ग्यू कर रहे हो एंड इन इंडिया देयर इज no authority on that particular legal point, so what you need to do is you need to find case laws in other jurisdictions. For example, US का कोई case law मिलता है, अब उस case law की binding value तो नहीं होगी, but उस case law की persuasive value तब बढ़ जाएगी अगर उसके facts आपके facts से similar है. तो you need to research those cases जिनके साथ आप एक parallel draw कर सकते हो अपने facts के साथ. Now the last point is that this is the main task. अब किसी भी मूट कोर्ट रिसर्च का जो प्रोग्रेशन है, किसी भी मूट कोर्ट रिसर्च का पर्पस जो है, दैट इज रिटन इन द 6th point. You need to hunt for secondary sources of research, and from those secondary sources you end up going to the primary sources. अंडरस्टैंड दिस वेरी केयरफुली. और बच्चा जब मूड प्रॉब्लम आती थी, पर्सनली मेरे लिए मैं बहुत कंफ्यूज हो जाता, क्या करूं, रिसर्च कैसे करूं, कहां से स्टार्ट करूं, एंड ऑल दोस क्वेश्चंस दे जस्ट बॉग यू डाउन. बट इट इज वेरी सिंपल. थोड़ा मैकेनिकल अप्रोच है तो इसलिए वो सिंपल हो जाती है. एग्जाम्पल, राइट टू प्रिवेसी की फिर से बात करते हैं. राइट टू प्रिवेसी आया, हमारा मूड प्रॉब्लम राइट टू प्रिवेसी पे आ गई. आई नो राइट टू प्रिवेसी आर्टिकल 21 पे है. आई नो आर्टिकल 21 जो है, दैट इज okay, I think Swachh Bharat is happening out there. So right to privacy is in article 21. Guys, hold on. Yeah, hi, I'm so sorry. So where was I? Yes, on the 6th point, the main focus of your research should be to first of all find a secondary source. जैसे मैं बता रहा था कि आर्टिकल 21 के लिए मैं सीधे डीडी बसु उठाऊंगा. ठीक है, एक स्टेप एकदम क्लियर हो गया, डीडी बसु ही उठाना है मुझे, बिल्कुल श्योर है ये. डीडी बसु में भी आई नीड टू गो टू दी आर्टिकल 21 वाला जो सेक्शन है, वहां जाना है. अब किसी भी कमेंट्री पे रिसर्च करने के लिए जस्ट नोट कि देयर आर 2 इंडेक्सिंग्स व्हिच आर डन इन अ कमेंट्री. एक इंडेक्स सेक्शन हमारा स्टार्टिंग में होता है, व्हिच इज द टेबल ऑफ कंटेंट्स, एंड अदर इंडेक्सिंग इज एट द बैक ऑफ द कमेंट्री, जहां पर जितने भी उस बुक में कॉन्सेप्ट्स हैं, जितने भी कीवर्ड्स हैं, वो सब पीछे दिए होते हैं इन एन अल्फाबेटिकल मैनर. दे आर अरेंज्ड इन एन अल्फाबेटिकल मैनर. वहां पे यू कैन जस्ट फाइंड राइट टू प्राइवेसी किन किन पेजेस पे दिया गया है, एंड यू कैन गो एंड कंसल्ट दोस पेजेस. फॉर एग्जाम्पल, पेज नंबर 80 पे राइट टू प्राइवेसी दिया है. मैं पेज नंबर 80 पे गया, मेरे को एक लाइन मिली और वो बहुत ज्यादा मेरे काम की नहीं थी, बट मुझे ये समझ में आ गया कि अच्छा, ये वाली जो लाइन राइट टू प्राइवेसी पे बोली है, ये इस केस में बोली है, बिकॉज फुटनोट्स में वो केस दिया होगा उस बुक में. नाउ आई विल गो टू दैट केस एंड रीड दैट केस. तो मेरे पास सेकेंडरी सोर्स था डीडी बसु, जो कि बाइंडिंग नहीं था. फ्रॉम दैट सेकेंडरी सोर्स आई विल बी गेटिंग माई प्राइमरी सोर्स, विच इज दैट केस लॉ जिसमें राइट टू प्राइवेसी की बात की गई थी. Okay, don't worry about the slideshow. We'll be back with the slideshow. Oh, so it must be a network error. So yes, where was I? We'll have in the end what we are supposed to have is binding authorities, जो कि हमें सिर्फ प्राइमरी सोर्सेज होंगे जो बाइंडिंग होंगे, जितने भी सेकेंडरी सोर्सेज होते हैं वो सिर्फ परसुएसिव होते हैं. तो चाहे वो डीडी बसु की कमेंट्री हो, कुछ भी बुक हो, कितनी भी अच्छी कमेंट्री हो, इट इज मियरली परसुएसिव. कोर्ट के ऊपर कोई ऑब्लिगेशन नहीं है कि वो आपकी बात माने. बट इफ इट्स अ जजमेंट विच यू कैन फाइंड इन डीडी बसु, तो वो सेकेंडरी से प्राइमरी सोर्स पे जाना ही इज योर ओनली टारगेट. नाउ यू कुड जस्ट गो टू मनुपात्रा, एसईसी ऑनलाइन और योर जर्नल इन योर स्कूल, इन योर कॉलेज, एंड जस्ट रीड दैट केस. बेटर होगा कि आप ऑनलाइन पढ़ो, क्योंकि उसमें आप फाइंड वाला ऑप्शन जो होता है उसमें कीवर्ड्स फाइंड करके आप पूरा केस लो बहुत जल्दी पढ़ सकते हो. तो yes, this is what you need to do in research. And yes, बहुत सारे बच्चे ये पूछते हैं कि ऑनलाइन डेटाबेसेस कौन कौन से हैं. गाइस, ड्यू टू दिस लॉकडाउन एंड ड्यू टू कोरोना, कॉलेजेस आर नॉट फंक्शनिंग, सो many resources, many databases are actually free now. We'll be sharing that list soon on our website, but yes, you could also go and check out all these databases जो अभी बिल्कुल free हो गए हैं और वो open source databases हो गए. Okay, there's some issue. कोई बात नहीं. Don't worry about the slides. You just be on the same page as I am. तो अभी तक हमने क्या कर लिया? हमारी mood problem आ गई है. हमने issues hunt कर लिए हैं. हमने keywords पढ़ लिए, proposition समझ लिए हैं, and we have researched on the issue. Issue पे research करने के बाद the next stage is now you get on the real shit. Now you get on the memorial making part. Okay. So memorial making में भी there are basically 3 aspects to the memorial. We are going to talk about all 3. One is drafting. The first one is drafting. Now, since you've researched, now you have all your research compiled in one place. Now you need to begin making arguments. अब उस research को fact से connect करके हमें we need to put it down on paper and we need to make our memorials. अब drafting में you are not supposed to have exceptionally good drafting skills in your first years and second years. No one expects that from you, but you need to know the basics of drafting. अब basics का मतलब ये you first of all, many students think कि, और ये बहुत बड़ा misconception है, बच्चों को लगता है कि जितने ज्यादा लैटिन फ्रेजेस यूज करूंगा मैं अपने आर्ग्यूमेंट्स में, जज उतना ज्यादा खुश हो जाएगा मेरे से. दैट इज एब्सोल्युटली रॉन्ग. मैं जितने ज्यादा लैटिन फ्रेजेस देखता हूँ मेरा उतना ज्यादा मूड ऑफ हो जाता है, क्योंकि मेरे को समझ में नहीं आ रही है वो चीज. मेरे को as a judge, what I want is to understand your argument in the most succinct language possible. जितना आसान भाषा में you can convey your argument, that's how much better it could be for you. Don't go for using randomly using Latin phrases. Just use your language of drafting should be, as the first point says, simple and impactful. Believe me guys, simplicity mein it actually has power, because I need, as a judge, I will not be struggling with your argument. Now, by simple, I do not mean at all that you use childlike language. If you want to praise something, you just can't write that Article 21 is so amazing, it's giving right to privacy. You can't write that. है ना? तो सिंपल का मतलब ये नहीं है कि बिल्कुल चाइल्ड-लाइक बच्चों जैसी लैंग्वेज हम यूज करें. एंड yes, keep your sentences short. Do not add बहुत ज्यादा and लगा के, but लगा के, therefore, hence, ये सारे conjunctions लगा के बच्चे बहुत लंबे sentences बना देते हैं. Those become tedious on whoever is judging your memorial or reading your argument. Try to frame as crisp sentences as possible and make it a rule, not only for your moot courts, for your answer writing in your exams, for research papers, and whenever you're practicing. Write simple, short, crisp sentences, and don't go for very flowery, or you get what I'm trying to say. The next thing is the method of drafting. Yes. Now, I am not sure how many of you know this, but this is very, very important, guys. IRAC method of drafting. So IRAC stands for, you can just jot it down. IRAC stands for issue, rule, argument and conclusion. So कोई भी मेमो का, जब हम मेमो खोल के देखते हैं ना, तो उसका ड्राफ्ट कैसे दिखता है. सबसे पहले ऊपर एक एक हेडिंग होती है इशू, फॉर एग्जाम्पल वेदर और नॉट राइट टू प्राइवेसी हैज बीन ब्रीच्ड, ये अगर इशू है हमारा क्वेश्चन मार्क, दिस इज योर इशू विच इज आई. नाउ कम्स द रूल, आई रैग भी बोलते हैं हम, आई लैग भी बोलते हैं. नाउ कम्स द रूल विच इज द लॉ. You need to state the law. You need to write that it has been opined in the Supreme. It has been opined by the Supreme Court or by the Apex Court in the Puttaswamy judgment. पूरा judgment का नाम लिखना है in the Puttaswamy judgment कि Article 21 में right to privacy दिया जा रहा है. ठीक है. This is the law. Now you laid down कि भाई Supreme Court, the highest law of the land, lay down कर दिया है. उसमें ये है कि right to privacy Article 21 में है. Now you laid down the rule. बिल्कुल सिंपली एक दो लाइन में लॉ लिखना है. हाँ, अब ये भी होता है कि अगर राइट टू प्राइवेसी जैसा, तो ये एक ऐसा एग्जांपल है जिसपे लॉ है हमारे पास. अगर ऐसा कोई लॉ नहीं होता, अगर परसुएसिव अथॉरिटीज होती, तो आपका जो लॉ लिखना है आपको वो थोड़ा सा एक्सटेंड हो जाता है, 3 लाइन 4 लाइन तक भी जा सकता है. इशू लिख दिया, लॉ लिख दिया. अब इसके बाद आता है हमारा आर्ग्यूमेंट. आर्ग्यूमेंट में जो हमने जस्ट ऊपर लॉ लिखा है ना अभी अभी, वी नीड टू अप्लाई आवर फैक्ट्स टू द लॉ विच इज स्टेटेड. जो हमने अभी अभी 2-3 लाइन में लॉ स्टेट किया है, उसमें वी विल अप्लाई आवर फैक्ट्स एंड जस्ट मेक आवर आर्ग्यूमेंट, क्योंकि बिकॉज देयर इज अ राइट टू प्राइवेसी एंड माय क्लाइंट के साथ, मेरे क्लाइंट के साथ ये हुआ है, देयरफॉर उसका राइट टू प्राइवेसी ब्रीच हुआ है. नाउ दिस लास्ट पार्ट, देयरफॉर हिज राइट टू प्राइवेसी इज ब्रीच, दैट इज द कंक्लूजन. ठीक है. इफ यू आर फ्रेमिंग एनी इशू, sub issue or sub issue, that should also follow the IRAC method of drafting. It just makes your draft very easier, very convenient. You will know how your arguments are proceeding. The judge will have a clue what to expect next. There'll be a structure which is most important, which is the most important part of oral pleadings, that your arguments need to be structured. So this is the way in which you can actually secure that consistency and the structure. Always follow the IRAC method of drafting. Okay, and not only in moot courts, but also for research papers, for उसमें अब issue नहीं लिखना होगा, but this writing the law, writing the argument and concluding it is the most easiest, and it's the most logical expression of your argument there can be. So just stick to it. Now comes the formatting part. Now guys, formatting, I know स्टार्टिंग में बहुत टास्क लगता है, कई सारे बच्चों को नहीं आता है, बट मैं तुम्हें बताता हूँ फॉर्मेटिंग के मार्क्स कैसे दिए जाते हैं. अगर 100 मार्क्स का मेमोरियल है, उस 100 मार्क्स में 30 मार्क्स आर फॉर फॉर्मेटिंग, तो बाय डिफॉल्ट यू हैव ऑलरेडी सिक्योर्ड दोस 30 मार्क्स बाय डिफॉल्ट, until and unless you just violate a rule. अगर आप खुद ही फॉन्ट साइज नहीं गलत कर दोगे, अगर आपको बस रूल्स फॉलो करने हैं, आपको बस ये देखना है 1.5 लाइन स्पेसिंग है, मेरा फॉन्ट 12 है, मेरा फॉन्ट साइज 12 है, फॉन्ट टाइम्स न्यू रोमन है, इफ ऑल दीज गाइडलाइंस आर मेट, वो 30 मार्क्स आपके कोई नहीं काट सकता. तो फॉर्मेटिंग के जो मार्क्स हैं, इफ यू आर लूजिंग मार्क्स ऑन फॉर्मेटिंग, that's it should not happen for a serious mooter. And yes, how to take a clue of how the formatting should be. कई सारे ऐसे मेमोज होते हैं जिनमें बहुत हैवी फॉर्मेटिंग होती है, बहुत सारी लाइंस होती हैं, बहुत सारा कुछ उसमें वो बहुत कुछ कर देते हैं, बॉर्डर्स होते हैं, बोल्ड होता है, इटैलिक होता है, सब कुछ कर देते हैं वो. कुछ मूव्स होते हैं जो बिल्कुल सिंपल होते हैं, उसमें कुछ नहीं, वो बस आर्ग्यूमेंट्स लिखते हैं. यू नाउ व्हाट यू नीड टू डू इज यू नीड टू पिक आउट द बेस्ट मेमोरियल्स जो पिछले साल के हैं फॉर दैट मूड इन विच यू आर पार्टिसिपेटिंग, एंड यू नीड टू टेक अ क्लू कि अच्छा, इफ दिस मेमो वन द बेस्ट मेमोरियल, व्हाट डिड इट डू डिफरेंटली, why did it won the best memo prize. तो अगर उन लोगों ने फॉर्मेटिंग ऐसी की हुई है, बहुत हैवी फॉर्मेटिंग की हुई है, and borders and shading, page border, bold lines, whatever, तो I think you should stick with that. Usually जो international moods होते हैं या tier 1 moods होते हैं, they don't focus very much on the formatting aspect, heavy formatting aspect. A basic minimum formatting would do. So yeah, you need to take your clue from the past best memorial. और हाँ, ड्राफ्टिंग में भी अगर आपको दिक्कत हो रही हो तो भी आप पास बेस्ट मेमोरियल्स उठा सकते हो, वहां से आपको ड्राफ्टिंग का अंदाजा मिल जाएगा. Yes, one more very important tip. Usually there are 3 team members, okay? तीनों का ड्राफ्टिंग स्टाइल अलग होगा. एक लिखता होगा एपेक्स कोर्ट ऑफ इंडिया, एक लिखता होगा सुप्रीम कोर्ट ऑफ इंडिया, एक लिख देगा SC, या फिर कोई लिख देगा द हाईएस्ट कोर्ट ऑफ दिस कंट्री, कुछ भी. तो यू नीड टू फिक्सेट अपॉन अ सिंगल वर्ड, और ऐसा सिर्फ सुप्रीम कोर्ट वाले कीवर्ड के लिए नहीं है, बाकी कई सारी चीजों के लिए है. आप सिनोनिमस वर्ड यूज मत करो बिकॉज इट कॉम्प्रोमाइजेस विद योर कंसिस्टेंसी. नाउ द लास्ट पार्ट इज एडिटिंग. एडिटिंग, मेमोरियल के एडिटिंग में मोस्ट इम्पॉर्टेंटली इज द प्रूफ रीडिंग वाला पार्ट. You need to proofread your memorial as many number of times as possible last में. And yes, do not proofread only by yourself. Distribute your memorials to your seniors, to your friends, to your colleagues. क्योंकि आप जब खुद अपना मेमो देखते हो, there's this bias which will not let you judge your memorial in the best possible manner. आप गलतियां नहीं देख पाते हो, आपके ब्रेन में bias होता है अपने आप, because you only have done that work. So distribute it all across. जहाँ पे जितनी ज्यादा गलतियां लोग मार्क कर पाए, पिन पॉइंट कर पाए, यू नीड टू वर्क ऑन देम मच. जितनी गलतियां मार्क हो पाएंगी उतना बेटर. द सेकेंड एस्पेक्ट ऑफ एडिटिंग इज चेकिंग द फॉर्मेटिंग. हर जगह का ये देख लो, लाइन स्पेसिंग, फॉन्ट साइज, दैट शुड नॉट बी कॉम्प्रोमाइज्ड. एंड फुटनोट्स जो है, फुटनोट्स में द फुटनोट शुड बी कंसिस्टेंट. और 200 पे जूम कर लो डॉक्यूमेंट अपना, 200% पे जूम कर लो, एंड देन सर्च द फुटनोट्स. एक भी फुल स्टॉप, एक भी ब्रैकेट गलत नहीं लगा होना चाहिए. दिस इज व्हाट यू डू इन द फाइनल एडिटिंग पार्ट. नाउ Lavanya, can we have the next slide? Proofreading, I think I've jotted down certain points for you. Yes. Now, once your memo is done, we very briefly touched upon the memorial making part, but yes, we have a paucity of time as well. Now, coming to the oral argument section, once the memo is submitted, just you directly begin your oral arguments preparation. Just take 1 day का gap and then begin with your preparation. Do not prolong this, क्योंकि ये बहुत गलत time होता है. You end up wasting a week or 10 days before you start preparing for oral rounds. Just take a day's break, और अगर serious mooter है तो he or she would not even take a day's break as well. Believe me. For oral arguments, the first point is definitely importance of English. It's not your fault if your English is not very good in your school. It's not your fault, believe me. But having now being studying in a law school, if you're still not working on your English speaking skills, that is your fault. I had my friends, I remember, I'll not name that guy, but in my college there was this guy जिसका English बिल्कुल बहुत गंदा था, and he worked so hard, और he actually, उसकी English speaking skills बहुत ज़्यादा improve हो गए थे. तो if he can do it, any one of you can. तो if don't get disheartened, I see there's this complex in students कि अगर उनको English नहीं आती है तो they are definitely on a back burner. Believe me guys, ऐसा कुछ नहीं है, but you need to equip yourself with English language, because हाई कोर्ट में और सुप्रीम कोर्ट में दिस इज द मोड ऑफ कम्युनिकेशन. डिस्ट्रिक्ट कोर्ट्स में और मदर टंग जो भी वहाँ पे उस कोर्ट में लैंग्वेज चल रही है, यू कैन प्रैक्टिस इन दैट, बट यू डेफिनेटली वांट टू गो टू द हाई कोर्ट और सुप्रीम कोर्ट. वहाँ पर यू नीड टू हैव अ गुड कमांड ऑन इंग्लिश. देयरफॉर स्टार्ट वर्किंग ऑन दिस इंग्लिश स्पीकिंग एज सून एज पॉसिबल. फर्स्ट ईयर, सेकेंड ईयर, जो भी हो, अपने इंग्लिश पे काम. देयर आर ऑनलाइन कोर्सेज, फ्री हैं, कोर्सेरा पे हैं इंग्लिश के कई सारे कोर्सेज. जस्ट बिगिन. कल गलतियां करने से बेहतर है कि आज ही गलतियां कर लो. तो जस्ट बिगिन योर प्रिपरेशन ऑफ इंग्लिश, जो भी है, इट विल हेल्प यू फॉर अ लॉन्ग टाइम. नाउ यस, मेमो बन गया है हमारा. नाउ वी हैव टू प्रिपेयर अ ट्रांसक्रिप्ट. ट्रांसक्रिप्ट क्या होता है? बेसिकली whenever you are going in an oral, जब आप oral arguments अपने submit कर रहे होते हो, you need to have a skeleton of the arguments or the pleadings which you are making in front of the court. So that very skeleton of arguments, that very skeleton of your arguments is known as a transcript. So it's basically not similar to a memorial. It has a lot of differences as compared to a memorial. For example, transcript, you need not submit that transcript either to the bench or to the organizers. It's only for your convenience and your purpose. In your memorials, you end up including many authorities on a certain point. But in your transcript, what you need to do is you just need to pull out the best authority, which is binding, which should be binding, the best authority which you have on a certain point of law. And then you need to just rely on that and argue on that while submitting your argument. There is no need to, bring all your arguments in your transcript and argue them. Just cull out the best argument and then put forth in front of the bench. And transcript may, yes, one important point is do not read from the transcript. Students do that, वो memo से ही पढ़ने लगते हैं बच्चे, but after the memo you need to make the transcript, and from the transcript also you are not allowed to read. It gives a very, very bad impression that you are not even prepared with your arguments. So yes, do not read from your argument, do not read from your transcript. It's just a basic outline. It should be just a basic outline of your arguments and not the sole repository of all your pleadings jahan se aap पढ़ के बोलोगे. Apart from the transcript, yes, the next question is how do we prepare a transcript? Now guys, any moot court transcript will have a proper structure. Now I've just jotted down the structure for you for ease. First of all, you need to begin with the introduction. Now, the introduction in a transcript will first of all deal with greeting the judges. You need to greet the judges, and then you need to introduce yourself. Not yourself, but the counsel that you are at that point of time. You need to introduce yourself and your party. And after that, you need to tell the bench the division of time. For example, 25 minutes says speaker one is dealing with issue one and two, and speaker one will be doing that within like say 15 minutes, and speaker two will be dealing with issue three in the next subsequent 10 minutes of the court's time. So you need to tell the division of time. ये तीन चीजें, greeting the judge or introducing yourself and division of time. These three will be the introductory part of your transcript. Now, the next thing in your transcript should be a brief synopsis of facts. It should your facts, mostly facts जो submit किए जाते हैं oral arguments में, वो जो preliminary rounds होते हैं वहाँ पर किए जाते हैं. Usually नहीं semis और finals में वो facts दोबारा submit नहीं करवाते हैं. But in any case, you need to be prepared with the facts which could be submitted within 30 seconds. 45 seconds, maximum 1 minute. Facts, your synopsis of facts cannot exceed 1 minute. मतलब you are wasting time if अगर वो 1 minute से ज़्यादा जा रहे हैं. Of course, until and unless the judge dwells on the facts way more than he's expected to do, तब बात अलग है. Apart from that, 1 minute is enough. After the facts, you need to tell him the roadmap of your pleadings. कि arguments कैसे proceed करेंगे. For example, if you are arguing on, yes, one of the example I jotted it down that we will, you can say that we will first submit that the crime was not committed. And secondly, if this court finds out that the crime was committed, then we'll submit that the respondent has immunity under any law, under the Rome statute. Okay. So Rome statute crime of transgression hota hai. I got involved with the law. So you need to put forth the structure of your arguments ताकि जो judge है उसके दिमाग में बिल्कुल clearly पता हो कि अच्छा right now the speaker is talking about this point. अगर judge के दिमाग में इतनी clarity है, उससे ज़्यादा अच्छा कुछ नहीं हो सकता oral rounds में, believe me, because if he's that clear, he can frame his questions, and if he's able to frame questions and ask you, that is the best your round could go. Obviously, not a lot of grilling will hamper the rounds, but you need to invite questions as well. So, अगर आपका structure clear है judge के दिमाग में, then he will definitely ask questions. He will be engaged in your structure. He will be engaged in your pleadings. You're halfway there if that is done. So yes, you need to then include a roadmap of your pleadings. After that, you need to just prepare. You need to put in your arguments in the transcript. और हाँ, arguments में एक चीज ध्यान रखना. A judge may ask question जो आपके arguments का structure disturb कर दे. So you need to have a proper, transition between the two issues. अगर आप कोई एक answer आपने कर दिया है and आपको पता है कि उस answer से आप किसी और issue पे jump कर सकते हो. So you need to have a proper transition between the two issues and between either two issues or the answer which you've given and between the subsequent issue. There should be a proper flow, proper transition between them. Yes. Another thing is that both the speakers, which this I've already told you, that both the speakers are expected to know all the issues. Yes, apart from that, key attributes. So, and whenever you're going for your oral rounds, please be properly dressed. That's your first impression. Pehla impression आपका memo होता है actually. क्योंकि आप कोर्ट रूम में जाने से पहले the judge is reading your memorial. You could be Miss India, you could be Mr. Universe, whatever, but the first impression which your judge will have of you will be from your memorial. So make sure your memorial is up to the mark, formatting एकदम अच्छी होनी चाहिए. And after that, you need to be very well dressed. You need to present yourself in a very poised manner. You need to be equipped with all the courtroom etiquettes, courtroom mannerisms. आपको पता होना चाहिए that you cannot pass a document directly to the judge. Any document which you need the bench to refer, you can only pass it through the court clerk. एक court clerk बैठा होगा, उसको आप दोगे and you will ask him to pass that to the judge with the bench's permission. Of course, these are the courtroom mannerisms and etiquettes which you need to know. A lot of them, but yeah. Now, yes, this also is an important aspect, how to deal with questions from the bench. Now, guys, judges can ask you questions on the law concerned with your facts. They can ask you questions on the facts of your case, and they can ask you questions just to throw you off track. Now, there are certain rules which you need to follow. Whenever a judge is asking questions, just put a smile on your face that you're welcoming his questions. Do not इतना grin मत करने लगा, हंसने मत लगना उसके ऊपर, उसको लगेगा वो क्या पूछ रहा है. So just put a smile on your face, and so that you are welcoming his question. And yes, next thing is, do not interrupt the judge while he's asking. वो कुछ भी बकवास पूछ रहा हो, कितना भी गलत question पूछ रहा हो, you should not be interrupting the judge. You let him complete his question, and then अगर उसके बाद आपको कोई disagreements है, आपको कुछ भी या फिर कुछ आंसर देना है, only after he's finished, you should speak. There might be questions in which the judge will ask you, counsel, I just need an answer in yes or no. वो फंसाने के लिए होते हैं questions. But if he is sticking up to that question that I need an answer in yes or no, give him an answer in yes or no. Do not deviate. Do not shy away from that. And if at all you think that you need to, exhibit your yes or no answer with a proper understanding, with a proper explanation, you can do that. Take his permission. अगर वो मना करता है तो, but yes or no questions को yes or no में answer कर देना चाहिए. Yes. Now, as I told you guys कि जब मैं पिछला वाला point discuss कर रहा था कि arguments आपके कैसे structured होने चाहिए, उसी तरीके से whenever you are answering any question from the bench, now that answer should also be connected to your structure of the arguments, to your structure of pleadings. So if you give an answer, you can just say that now your lordship, this leads to my main submission, which is, तो ऐसे आप उस answer से अपने issue पे वापस से transit कर सकते हो, and that structure is maintained, which I already told you is the most important part. Now the last point is moot court compendiums. Moot court compendiums, guys, they are just a compilation of all the authorities which you are using in your oral pleadings, not in your memorial. Memorial में अगर 100 cases हैं, तो it's not important to print out all those 100 cases. So जितने भी arguments, जितने भी authorities को आप अपने oral pleadings में use करने वाले हो, you should have a compilation of all those authorities for the referral of the bench. It may so happen that the judge is not aware about that case, judge is not aware about that law, and the organizers don't have a copy of it. So it's better that you are yourself prepared with all these things. That is the compendium. Now, 2-3 things which need to be kept in mind, that your compendium should be, again, the compendium should also be structured. उसमें सबसे पहले cases होंगे, फिर अगर articles refer कर रहे हो तो articles उसमें सारे compiled होंगे. अच्छा हाँ, अगर ऐसे cases हैं जो कि 100 pages के हैं या फिर 30-40 pages के हैं, do you need to print those cases in entirety? Absolutely not. You just need to print the first page, और उसके बाद जो page आप cite करना चाहते हो उसके एक page पहले और एक page बाद, and that page of course, वो 4-5 page में आप submit कर सकते हो in your compendium. Do not print the whole cases in entirety. पूरे cases print करने की जरूरत नहीं है. Don't waste paper, and your compendiums will end up being this thick. You don't want that. Another thing is that your compendium should highlight. For example, अगर एक पेज पे किसी केस में आपको एक लाइन रेफर करवानी है जज को, that line, make sure that line is highlighted. Your compendium should be bookmarked. सारे papers slits लगा देना उस पे compendium पे कि ये वाला केस है, ये वाला केस है, so that you don't you are not flipping pages in front of the judge. You should know कि अच्छा ये वाला जो केस है ये इस पेज नंबर पे, whenever you are submitting an argument, for example, again Puttaswamy judgment अगर आपके compendium में है and you're stating in the Puttaswamy judgment this and this was stated, your lordships may refer to page number dash dash of the compendium. तो आपको compendium में भी just jot down कि इस compendium पे इस पेज पे ये authorities हैं for ready referral of the judge. You don't want the judge to keep hunt down your authorities. Okay. I think this is all about compendium. Or yeah, one more question which comes up is, do we need to make 2 compendiums or 1 compendium would do? Ideally you should make 2, one for the aggrieved party wala side and other for the party who's responding. You should go on with 2 compendiums. And it's many moot courts, they don't prescribe having a compendium until and unless it is not prohibited. I will recommend you all to have a compendium and go with it. So yes, this is a brief about the oral arguments. Most important part in this was the transcript, the structure of the transcript, and dealing questions of the bench. So yeah, let's move on to the next slide, which is I think the last slide. Lavanya, yeah, yes. So ये बहुत इम्पॉर्टेंट टास्क होता है. मेमो सबमिट होने के बाद रिसर्चर्स एकदम बैक सीट पे चले आते हैं, वो चिल करने लगते हैं, उनको लगता है कि अब मेरा काम हो गया है, अब मूट इन लोग की जिम्मेदारी है. आई डोंट केयर नाउ. दिस शुड नॉट हैपन. रिसर्चर मेमो सबमिशन के बाद भी बहुत ज़्यादा कॉन्ट्रीब्यूट कर सकता है. मोस्ट इम्पॉर्टेंटली the third point, guys, as you see, is conducting practicing rounds. You don't want your speakers to waste their time in conducting those rounds. You should, a researcher should reach out to people to ask them to judge the speakers, and you should go to not only to experts in law. अपने teachers के पास जाओ कि हमारी team को judge कर लो. सिर्फ teachers के पास नहीं, first years के पास भी जाओ. This team, this JSF team which went to the semi-finalists, which I told you about, these guys practiced. They were in 5th years, 4th years. इन लोगों ने फर्स्ट ईयर के बच्चों के सामने अपने राउंड्स प्रैक्टिस किए थे, ओनली टू नो कि आर देयर आर्ग्यूमेंट्स सिंपल इनफ टू बी कन्वेड टू इवन एनीवन हु हैज नो नॉलेज ऑफ इंटरनेशनल लॉ. सो दिस इज हाउ बेसिक यू कैन गो, हाउ दिस इज द एक्सपर्ट मोड ऑफ प्रिपरेशन, जहां तक जा सकते हो, जहां तक जाना चाहिए. So yeah, रिसर्चर का मेन काम होता है कि वो प्रैक्टिस राउंड्स कंडक्ट करवाए एंड ही assembles all the inputs, वो दोनों स्पीकर्स को चेक में रखे, whatever. Apart from that, it may so happen कि आपने जब मेमो सबमिट किया हो, in a hurry you were not able to focus on some of the argument, or after the submission you realize कि इस वाले particular submission में there is something missing, or maybe you get some authority which is more binding and that authority was not included in your memo in the first place. So this additional research for oral rounds है ना, कि अगर आपको वो arguments oral round में देना है लेकिन memo में नहीं है, तो ये सारी additional research जो है ये researcher की responsibility होगी after the memo is submitted. Second task is preparing a question bank. Now judges जो question पूछते हैं, a good preparation will definitely guess most of those questions. A good speaker who has practiced hard will know the questions which he is going to invite from the bench. तो वो जो basic rudimentary questions हैं जो आपको पता है कि ये तो पूछे ही जाएंगे, ये सारे questions researcher को ये सारे questions prepare कर लेने चाहिए and ideal answers to them. Yes, I think this is it. Researcher का role, do not think कि researcher का role memo submission के बाद diminish हो जाता है. He needs to be active. He needs the speakers to be on their toes. He needs to motivate them. In the end, the trophy is of the team, not for the speakers. So yeah, I guess this is it. Now we can get back to schedule.
Should I begin with question answer session, sir?
Yes, schedule.
Okay, thank you so much, sir, for sharing in so detailed and in beautiful manner. Now I would like to take questions from our participants. So the very first question is, what all things do we have to keep in mind while making a memorial, and how to do research for memorial drafting?
Memorial drafting के लिए I'll address the second part of the question first. Memorial drafting के लिए you need not do research. What you need to do is you need to you need to pick out the best memos. For example, BCI, जो भी बहुत अच्छे moot court competitions हैं, just go and search for their best memorials and read their arguments. The manner in which they try to float their authorities, the manner in which they are trying to, you know, submit their arguments in alternative. एक alternative arguments एक चीज होती है, you'll know. जैसे कि मैंने एक argument submit किया, and if that does not land well with the bench, I will submit the next argument in alternative. कि ठीक है यार, तुम ये argument नहीं मान रहे हो, तो मेरा ये argument मान लो. So you need to know how to write those arguments. The best way, how I personally learned drafting from reading the best memorials. जो पिछले साल best memorials जीते हैं, मैंने वो arguments देखे, उनका structure देखा. Sometimes you are not even sure कि paragraph किस word से start करूं, और उसमें बहुत time लग जाता है किस word को furthermore से start करूं, henceforth से start करूं. So you can get a clue from these best memorials. Now, Shajal, can I have the first part of the question? I'm missing it.
Yes, so the first part, what all the things do we have to keep in mind while making a memorial?
Okay, it's a very open-ended question. You need to keep in mind a lot of things while making a memorial. But for starters, I'd say yes, simplicity of your memorial will go way beyond than you expect. वो बहुत help करता है if your memo is simple, because it lets you to convey your arguments in a much simpler fashion. And in the end, it's the judge who's responsible for marking you. Yes, another very, very important point, which again I told you guys, do not deviate from the rules. अगर कुछ rules लिखे हुए हैं, कुछ ही rules होते हैं, line spacing, paragraph spacing, footnotes के लिए अलग दे देंगे, कभी-कभी header footer के लिए अलग दे देंगे. Just stick to them. What I used to do, I used to make a cheat sheet of those rules. वो 7-8 rules में छोटे से पेज पे लिख देता था, and जब मैं proof reading कर रहा होता था, तो they were just in front of me, and I made sure कि मेरा एक भी memo का page is not in violation of those rules. So these all little bit things you need to keep in mind. And yes, do not first year, मैं सारे do nots बता रहा हूँ अभी, do's I guess मैं बता चुका हूँ इसलिए. First years में बहुत ज़्यादा ये issue होता है, they think some argument is very important and they just end up writing दो pages का paragraph लिख देते हैं वो. This is absolutely wrong. ये गलत practice है. If you think some argument is heavy enough to, you know, to elaborate on it, just divide it into sub issues. उनको दो सब issues में या फिर और ज़्यादा बड़ा है तो सब issues में divide कर दो, but avoid writing lengthy paragraphs. They will derail the judge from being attentive, and it will be your loss.
Okay, so the second question is, what are the things to be mentioned in argument advanced section?
Arguments advanced, okay, that's the most important. First of all, that's the most important part of your memorial. Arguments advanced will contain all the issues, all the research which you've done. So ideally, a page of argument advanced, सबसे पहले सबसे first issue will be written, which is mostly the maintainability issue, which states whether or not this plaint is maintainable. Now, just after that, आप उसमें अपना arguments लिखना चालू कर दोगे in the IRAC format, which I told you, and then you will have all your authorities, be it the case law, be it provisions of law, be it articles, be it any interpretation from any encyclopedia, be it any online resource. All those authorities need to be in those in the arguments advanced section. All your arguments will be in the arguments advanced section. और कहीं पे citations नहीं डाली जाती है, footnotes नहीं डाले जाते हैं. So arguments advanced section basically deals with all the issues and your arguments. Shajal, I guess you're muted.
How we choose which moot court is good for first and second year students?
Again, this is the priority of the first year and second year student only. One friend of mine, she went to WBNUJS. She, in her first year, she took, I guess, she went for Viz Hong Kong के लिए गई थी वो, and because her team also had fourth year students, she managed to be in the octa final rounds, I guess. I'm not sure. Octa finals से उसके ऊपर गई थी, and she was in her first year. So she got lucky also. She worked hard also. But you need to know if you want to win or you just want experience. The probability of winning a Jessup in your first year is not that high as compared to a tier 3 moot. And winning a moot, I went for a moot which was winnable. ठीक है? तो मुझे यही था that I want a trophy. That's it. That was all my concern was. So you need to figure out अगर ऐसा scene है कि आपको जीतना है moot, go for low tier moots, tier 3, tier 2 moots. Don't go for moots जिनमें 6 महीने साल भर का preparation चाहिए. या बिकॉज आपका फर्स्ट ईयर में आपको एक्सपीरियंस कम होता है, थ्रेशोल्ड कम होता है, तो एंड इफ यू वांट टू गेन एक्सपीरियंस then just go for a good team and hunt down good mood and just slog yourself into the preparation. You'll gain a lot of experience. और फिर second year third year में कोई winnable अच्छा move कर सकता है.
Okay, so next question is key ingredients to being confident and humble both while participating in moot court competition.
Humility is not something which you only carry for the oral rounds. If you are a humble person, it will reflect while you're delivering your arguments as well. So in general, I'd say that try to develop tolerance in which ताकि judge ने अगर कुछ गलत question भी पूछा है तो you can't mock the judge. This thing happened with me in my first intra university rounds. तो my teammate, one of a very dear friend of mine, तो उससे जज ने बहुत कुछ basic question पूछ लिया because a very basic statement was not cited. So a statement like Article 21 states that Article 21 incorporates right to life. ऐसा statement उसने कुछ शायद cite नहीं किया था. तो judge asked कि where do I get this from? ये मतलब how do I believe that it is true? तो उसने बोल दिया your lordship, the council presumes it to be in the general knowledge of your lordship. ऐसे करके उसने कुछ बहुत ही insulted that judge. So you need not do that. Be very respectful towards the bench. Come bolo whenever the judge finishes the question, only then you are allowed to speak. Do not interrupt the judge. Judge kitna bhi galat bol raha ho, you just have to put a smile on your face and if you are disagreeing also, you should disagree very respectfully with very much obedience towards the bench, because it's not the judge's wisdom which you are respecting, it's the seat on which he's sitting which you respect. So yeah, there's no hack of developing some humility in a day or two. You just need to have it over time and with practice.
Okay, so next question is, shall we use transcript just to look over the headings so as not to lose any point if missed by chance?
Yes, that is one benefit of the transcript, definitely. But yeah, transcript should not be used, as I said, to read the arguments. You can just take clues from the transcript. कि अच्छा हाँ ये वाला argument हो गया, and just keep a pen in your hand, just keep marking कि अच्छा ये arguments मैंने successfully submit कर दिए हैं. For example, if speaker 1 is there and speaker 1 has 4 arguments, he is not able to submit the third argument. So he can just put a separate mark कि third argument मैंने successfully submit नहीं किया है. So whenever speaker 2 comes, he can ask the bench's permission to address that third point before proceeding with his own arguments, so that all the arguments are successfully submitted. So yeah, I guess this is one of the use of transcript as well.
Okay, so next question is, should be the memorial as in detail as it can be?
Okay, no. I think it is a straitjacket answer. It's not a research paper. You need not delve into the jurisprudence of the law or the facts in entirety. Memo का मतलब ही है that you are trying to summarize your arguments. And but अच्छा, one thing which needs to be kept in mind is, if you think that you're going to use something in your oral pleadings, you need to make sure that that particular authority, that particular argument is in your document, is in your memorial. Because in real courts, what happens, आप जब movies में देखा होगा कि whenever this suddenly some party comes up with some evidence, एकदम अचानक से out of the blue कि हमारे पास ये evidence है और ये मुजरिम है, whatever. So the other party says, we were not notified about this. We were not notified about this evidence. So whatever authority you are using, you need to put that authority in your memorial, because आपके oral round से पहले both the teams exchange the memorial. It is for the very purpose that both the teams know what the other team is going to argue. So if you are going to argue something which is not in your memorial, the bench will not accept it. So you need to take permission of the bench. Otherwise, उसके अलावा you just need to make sure कि आपके memo में वो सारे arguments हैं. Did I refer to the question correctly? Because I don't think I did. I answered something else.
No, sir, you covered.
Okay, all right.
Okay, the next question is, what if we explain the Latin maxims as well? Then can we use them?
You again, the last question से ही इसका clue लूँगा मैं. You will end up wasting space. आपको Latin maxims के इतना पीछे क्यों पढ़ना है? Latin maxims का बच्चों first year में इतना enthusiasm होता है. समझ में नहीं आते हैं but they still want to use it because उन्हें लगता है कि अगले इसको भी समझ में नहीं आएंगे, so he'll think मुझे समझ में आते हैं. But avoid using Latin maxims at मतलब बिल्कुल अगर जैसे if it's sine qua non then you use it. But like you noticed, I said sine qua non जिसकी जरूरत नहीं थी. I could have just said if it's mandatory. तो अगर mandatory है तो use करो, but using sine qua non for mandatory is not recommended. So just use, for example, actus reus. अगर actus reus use करना है, it can be used while establishing a crime. कि mens rea और actus reus ये दोनों आप use कर सकते हो. But बहुत ज़्यादा overuse of Latin maxims tend to again derail the judge's attention. So do not explain any Latin maxim until and unless it's necessary. Yeah.
Okay, sir. Next question. If it's an online Moot, then should we be sending a compendium?
You can, these are genuine queries which students are facing these days. You can just ask the organizers, you can inquire about this to the organizers, क्योंकि हर mood के अलग-अलग scenarios होते हैं. If they require a compendium, just prepare a compendium and send them, because preparing a compendium is easier as compared to getting it printed and sending it or taking it. So you can refer these queries to the organizers. They'll let you know what the best route of action could be.
Okay, sir. Thank you so much for answering the questions asked by participants, and thank you so much for settling your time aside for this insightful webinar.
I'm really obliged that you guys had me. I had fun. I really hope that you guys learned something out of this and it benefits you in the longer run. That's it.
Yes, thank you, sir.
Thank you so much.
Thank you, sir.
Okay.